Okay, good morning, everybody, and thank you for joining us for our webinar entitled Lead-Based Paint Annual Notice and Record Keeping, an Owner's Guide to Compliance in New York City. This webinar is being hosted by HPD's Office of Enforcement and Neighborhood Services, or ENS for short. We are the office within HPD that focuses on preserving the quality and safety of New York City's existing housing stock. And we are the part of HPD that employs inspectors and other field staff and professionals to enforce the law and ensure that the housing stock is safe and high quality for all New Yorkers. Let's introduce ourselves. My name is Phil Weitzman. I'm a senior trainer here within ENS, where I work with housing inspectors, our clerical staff, and put on events for the public like this one. And I'd also like to introduce Joseph Ayoub. Would you like to introduce yourself, Joe?
Hi, good morning, everybody. Pleasure being here this morning with you.
And Chief Ayoub is the lead-based paint administrative chief. He's one of our foremost experts on the topics that we're going to be delving into here today. So we're very happy to have him. Before we get into the bulk of the webinar, just a few preliminaries. First, we'd like to give you a tour of the webinar resources. So this is the panel that you'll see if you joined our webinar on a laptop or desktop computer. And the two features I want to direct your attention to are the handouts and the questions. The handouts are a few attachments that we have included here for easy reference, and I'll refer to those as we go through the webinar. If anybody can't access the handouts, or if you're joining the recorded version of this webinar, because we will be sharing a recording, you can find all of the handouts on our website at www.nyc.gov/lead-based-paint. I'll be repeating that from time to time throughout the webinar. The other very important feature is the questions and chat. This is how you can communicate with us during this webinar. Please do let us know if you're having any kind of technical difficulties, and one of our staff will correspond with you to try and assist. In addition, please feel free to submit your questions on the subject matter at any time they occur to you. So we have some time at the end reserved for Q&A, but feel free to submit your questions whenever they occur to you, and we'll answer as many questions as we can. Now, here are what the interfaces are going to look like on smartphones. We have an example for Android and an example for iPhone. They're a little different, and they may even differ between different models of Android phone, but the main point is to access the questions, you're going to look for a question mark. To access the handouts, you are going to look for a curled piece of paper. At the end of this webinar, we're going to share a survey with you. We really appreciate it if you could take a moment to let us know what you thought of the webinar. We always read your comments very carefully. And as I had just mentioned, video recording of this session will be available. If you've registered for this webinar, you'll automatically receive an email within about a day with a link to the recording of this webinar. And in addition, we will post this to our YouTube page at the absolute latest on Monday, but probably by the end of business tomorrow. So this will also be available on HPD's website, and at our lead-based paint page, we'll have a link to that YouTube video. A disclaimer, this presentation is for informational purposes only, and it's not legal advice. So this is very important. For specific legal advice for your situation, you should contact an attorney. This presentation is not a complete statement of building owners' responsibilities relating to lead-based paint or any other topic. So we can't cover everything today. We're going to give you an overview of today's topic. And our audience for this presentation are building owners who have some existing familiarity with the city's lead-based paint rules. So we do have an introductory webinar available at our website that you can look at for an introduction and for more background, but we're going to be going a little deeper into the topics today. Our imaginary audience for this webinar already has some awareness of the lead-based paint rules. Another important thing to mention is that our topic today is New York City's Local Law 1 of 2004 as amended. So that's the New York City lead-based paint in residential housing safety law. There are also federal and state statutes that may apply in some situations, but we're not going to go over those today. Today we're focusing on HPD's jurisdiction because this webinar is being hosted by us, HPD. And so we're really talking about our role, HPD's role in lead-based paint enforcement and what that means for you as a property owner. And just once again, this presentation is a general guide to today's topics. It's very important as a building owner to use your own judgment to adapt the suggestions and principles we're going to share with you today in order to fully comply with the law. So we want to get you started with this webinar, but you will have to take ownership of these topics yourself in order to fully comply with the law, but by a combination of doing your own research and, if you feel it's necessary, consulting with a lawyer in order to get legal advice on these topics. All right, so we'd like to get to know you a little bit as we move ahead. So let us know which of the following best describes you. I'm going to go ahead and launch a poll here. Oops, let's see. And just let us know a little bit about yourself. This always helps us in making sure that we are speaking to your concerns as we move through the webinar. I see about 2/3 of us have voted. I'm going to go ahead and close the votes in 5 seconds. 4, 3, 2, 1. Okay, and let's see what everybody said. All right, so it looks like the vast majority of our audience, about 88%, are building owners or managing agents or supers. And that's our intended audience for this webinar. That's sort of the audience that I'm going to be speaking to as we move through today's presentation. But I see we also have 9% who identified as other, and a few tenants, a few advocates, policy analysts, or students. And I want to welcome all of you as well. There's still plenty for you to learn here, and the information is going to apply for you. But I'll sort of be speaking to owners as my main audience today. But especially for you tenants, the information is still relevant to you because it explains the responsibilities your building owner has to help protect you and your children from lead-based paint hazards. Okay, and one other question. We want to get a sense of how familiar you are with these topics. So go ahead and let us know if you've watched a webinar before. Okay, I see about 2/3 of us have voted. I'm going to go ahead and close this poll in 5, 4, 3, 2, 1, and let's see how everybody voted. Okay, so about 1/3 of our audience has attended one of these webinars before, and that's a great thing. Your attendance at the previous webinar should prepare you very well for the current one. A little less than 2/3 of the audience have never seen a webinar before, and that's okay. There's still plenty for you to learn, and we're going to spend a decent introductory chunk reviewing the basics here, but just something to keep in mind that this webinar is going to be a little bit more advanced. And so if you're feeling a little lost with the topic, that's maybe to be expected if this is your introduction to these topics. And again, we'll point you to many other resources where you can go ahead and catch up on the basics as you educate yourself on this topic. But whether it's your first time or your 10th time, welcome. We're happy to have you here for today's presentation. So what are we going to cover today? We're going to start by just reviewing a lot of the very basics. So we do want to establish the big picture of lead-based paint compliance in New York City. And then we're going to have two topics that relate to each other that we're going to focus on for the rest of the presentation. The first is the required annual notice and investigation. And the second is owners' requirements to keep records of all lead-based paint activities in New York City. And so in part 4 of the presentation, what we're going to do is combine those two topics. So we are going to use the annual notice and investigation process as an example of what kind of records must be kept for lead-based paint activities. And we're going to do that by showing a step-by-step demo that will be an example of one way that you could keep records. In demonstrating this, we're going to be showing how you can use a tool that HPD created to assist you in your lead-based paint record keeping, which is our sample forms. The sample forms are available on our website, and they are all attached as handouts to this webinar as well. So it's not required to use the sample forms, but many people find it helpful. So we'll be using them in our record keeping demonstration. And then we'll have a few final notes and wrap up and time for questions and answers. Some of you who have been checking your bulletins may have noticed that there are a number of big changes and additional requirements coming in the world of lead-based paint, and we will spend just a moment summarizing those in our final notes and wrap up. But most of our presentation is going to be focused on the annual notice and investigation and record-keeping requirements today. Okay. Again, we have many other webinars that go into detail on all of these topics. I'll be referring to these throughout the presentation, and they're available at our website, which is, again, www.nyc.gov/lead-based-paint. I keep mentioning the hyphens because if you forget to put those in, then you'll actually end up at a different city website that's also helpful in relating to lead-based paint, but it's not the one we're referring to today. And I just went ahead and put that link in the chat for you as well. So as our first part of the main presentation, let's review the basic big picture of lead-based paint safety in New York City. The first thing is the most important thing. It's why we're here discussing this topic. Lead-based paint is dangerous to children. So children are especially vulnerable to lead paint for two reasons. The first is that their brains are still developing. So any lead poisoning a child receives is much more harmful to that child than the same amount of lead would be to an adult, because an adult's brain has already developed, whereas a child's has not. And in addition, children explore their environments through what is called hand-to-mouth activity, as we see in the photo here. So if there is lead dust, if there are lead paint chips in an apartment, a child is much more likely to ingest those. So a child is also going to take in more lead poisoning in a given environment than an adult would be likely to in that same environment. Because of these risks, the New York City banned the use of lead-based paint in residential housing starting in January 1st, 1960, and then the US federal government did the same on January 1st, 1978. These two dates are extremely important to keep in mind in understanding the various lead-based paint safety requirements that exist in our country, 1960 and 1978. So let's talk about some of the features of New York City's lead safety law. One of the most important features or concepts is this idea of a presumption of having lead-based paint. And the way that this works is that what the law basically says is that lead-based paint is so dangerous that in a lot of situations, we are going to assume or presume that paint has lead unless it's proven otherwise. So that's going to happen for buildings built before New York City banned lead-based paint, which again, that date was January 1st, 1960. And for almost all buildings, so really any building with a tenant-occupied unit is another way of rephrasing this point you see on the screen. A multiple dwelling, which is a building with 3 or more residential units, or a private dwelling, which is a building with 1 or 2 residential units with a tenant-occupied unit. So again, this is really any building with a rental unit in New York City housing is the shorter way to summarize that was built before 1960. Now, one other thing to mention is that there are a smaller group of buildings that were built between 1960 and 1978, which was that date that the US federal government banned lead-based paint in residential housing. In those buildings, Local Law 1 is also going to have this, is going to apply in cases where the owner has actual knowledge of lead-based paint. So if you know that there's lead-based paint in your building, the law is going to apply to you even if it was built after 1960, assuming that your building was built before 1978. If your building was built after 1978, it's very unusual to have lead-based paint. So one other key concept, many of the requirements of Local Law 1 kick in when there's a child under the age of 6, a vulnerable child residing in the unit. And the definition of resides was recently clarified under the law. And what it means is that the child lives in the unit or routinely spends 10 hours or more per week in the unit. And so it's important to keep this 10 hours or more per week definition in mind. Many tenants, if you ask them, does a child live in their unit, may say no, but that same tenant might say yes if you ask, does a child spend time in the unit? It could be that they are babysitting their neighbors' children 3 hours a day, 5 days a week. Well, they might not say the child lives in the unit, but that's going to be 3 hours a day times 5 days a week is going to be 15 hours per week, which is more than 10 hours per week, and therefore that child would be said to reside in that unit. So something helpful to keep in mind. Now, even though under the law, we assume that a large class of buildings has lead-based paint, that does not mean that those buildings aren't in violation. Even if the paint is in fact tested in one of those buildings and shown to have lead, that in itself is not a violation of New York City law. So this is the other key concept for understanding New York City's Local Law 1 is that it focuses on lead-based paint hazards. So lead-based paint is not considered to be an immediate danger. It's still not great, but it's not an immediate danger as long as it remains covered up under layers of intact non-lead paint. So the law identifies two general major concerns, which are going to be deteriorated paint. We've got a great example of that here in the picture at right of some peeling paint. And in some cases, paint on high-risk surfaces, particularly surfaces that rub against each other on doors and windows, also called door and window friction surfaces. There are a few other kinds of high-risk surfaces as well. And then the law pays particular attention when there is an actual child present in the environment who could be a victim of that lead that's there in there, that high-risk lead that's in their environment. So generally speaking, violations are going to come in when we have deteriorated paint or paint on high-risk surfaces and the presence of a child. There are many more details, but those are the sort of the biggest factors that you're going to see that will trigger a violation under Local Law 1. So what does Local Law 1 expect building owners to do? Well, it expects them to be proactive in preventing lead-based paint. Being proactive means preventing a child from being poisoned in the first place. And the word proactive is the opposite of the word reactive. Reactive would mean waiting until a child is poisoned and then seeking to make their environment safer. But New York City law requires building owners to be proactive. And so there are a lot of different features with this. One of them is what we're going to talk about today, the annual notice and investigation, finding out where there are children in units in your buildings and then making those units safe from lead-based paint hazards. There are also steps that are going to be required whenever an apartment is vacant. And so that's an additional part of the proactive requirements. And owners also have to be sure that whenever work is done that disturbs lead-based paint, that work is done safely, namely by certified contractors who use safe work practices for working with lead-based paint. So owners have to be proactive under Local Law 1. One newer requirement to mention that adds to owners' proactive responsibilities is owners are required to test all rental units for the presence of lead-based paint by August 2025. It hasn't gone into effect, but soon an additional requirement will be introduced to test common areas by August 2025 as well. So this is something to be aware of. When we talk about testing, we're really talking about XRF testing using an X-ray fluorescence machine, which will require a licensed lead inspector. The good news about this requirement is that it's going to give you a thorough index of all of the lead-based paint that exists in your building, which will be the basis for applying for an exemption, where owners are able to show that there's no lead-based paint in their building, or on a unit-by-unit basis, then they can apply for an exemption from many of the requirements of Local Law 1. So let's review some of this information. We want to help you understand whether Local Law 1 requirements apply to your building. So I'm going to go ahead and send out another poll, and we're just going to find out, when was your building built? If you own or manage multiple buildings, just choose the oldest building. And of course, those of you who are joining us as tenants or other non-landlords, you can just go ahead and say, I don't know, or you could choose the building where you reside within New York City. Okay, I see about half of us have voted. I'll give it about 5 more seconds. 5, 4, 3, 2, 1. And let's see how everybody did. Okay, so a little more than 2/3 of our audience owns a building or lives in a building that was built before January 1st, 1960. And in those buildings, you can be sure that Local Law 1 requirements apply. We've got 12% of our audience who own a building built between 1960 and 78. Now, in your case, unless there is actual knowledge of lead-based paint in your building, then the requirements of Local Law 1 will not apply for your building. However, you may still want to watch our video on safe work practices. The federal safe work practices requirements for working with lead-based paint are still going to apply in your building if your building was built before 1978. So that's definitely something to be aware of. And now for those of you whose building was built after January 1st, 1978, there's great news for you. It is very, very unlikely that there is lead-based paint in your building. And neither the federal rules nor Local Law 1 are going to apply in your building. So what we're going to cover, these requirements are not expected of you, and the actual risk is very low in your building as well. Now, for the 10% of you who don't know, this is going to be your key starting fact for determining whether the requirements we're about to describe to you today do indeed apply for your building. So that's going to be an important piece of information for you to look up. And please do keep in mind that if your building was built after 1978, then what we're about to discuss will not be required by law for your building. And we're just going to do one other similar question to assess if Local Law 1 applies to your building, which is, do you own or manage a multiple dwelling or a private dwelling with at least one tenant occupied unit, at least one rental unit? So there's a variety of possibilities here. Okay, I see about 1/3 of us have voted. I'll give it a little more time to read all the choices. Some people might own a multiple dwelling. Some people might own a PD, private dwelling with a rental unit. Some people might own both. All right, and about 2/3 of us have voted. So let's go ahead and take a look at these results. Okay, so 5% of us aren't building owners or managers. So that's good to know. And now the vast majority of building owners or managers who voted, you are in a multiple dwelling or a private dwelling with a rental unit, or rather you own or manage that. And so in that case, Local Law 1 applies to your building, assuming that the dates we discussed in the previous poll also apply. But for the 2% of us who own a private dwelling where only the owner resides, you should be aware that these Local Law 1 requirements do not apply to you. So these record keeping requirements, the other details, You will still want to keep federal safe work practices in mind if your private dwelling was built before 1978, but otherwise these requirements don't apply to you. However, just because the law does not force you to follow these procedures, if your building was built before 78 and especially before 1960, there is a risk that lead-based paint is indeed present in your building and could be affecting any children that spend time in your building. So although the law doesn't require you to follow the prescribed steps that we're sharing, lead-based paint may still be an issue. And so you may wish to continue with this webinar just to get a sense of what it takes in order to keep tenants safe, and certainly do what you need to do to keep your tenants safe. But you will not have to do it in the way that is prescribed by law for the other kinds of buildings we're talking about. Okay, we're moving through our introduction here, and we want to start by addressing a common question that almost always comes after the previous information, which is people will tell us, my building was built before 1960, so local law 1 is going to apply there, but it was gut renovated, so I believe that there's no lead-based paint. Do all of the local law 1 responsibilities still apply to a building that is gut renovated, including the turnover and the testing requirements? And our answer is going to be yes. The way local law 1 is structured is the presumption of lead applies to all buildings with a building built day on the C of O that is before 1960. So even though you know that you paid for a gut renovation, even though you believe that there is no lead-based paint, the presumption of lead-based paint and all of the responsibilities that go with that under local law 1 is still going to apply to your building. And I do want to point out that even in cases of gut renovation, certain building components such as window frames, risers, radiators are often reused. So just the fact of a gut renovation in itself does not necessarily show that there's no lead-based paint in the building. But beyond that, even if you are completely sure that there's no lead-based paint in your building, the way the law is structured, this presumption of lead is still going to apply. And so then the common follow-up question is, I'm sure there's no lead-based paint in any unit in my building. Is there anything I can do? And our answer there is yes, you can arrange for testing to show that there's no lead-based paint. So you will use those testing records to your benefit. And then you can apply for a formal exemption with HPD. And we have a whole webinar on exemptions available on our website that goes into great detail on that process. And that is how you can reduce your lead-based paint responsibilities. So if there's no lead paint in your building, you can arrange for testing to show that. And again, that testing is now required to take place by August 2025 anyway, so you'll have to do it. And once you have those records in hand, you can get your exemption. Now, for anyone who's feeling a bit overwhelmed with this topic, who's getting started, we just want to highlight there is a lot to lead-based paint, but there's some affordable, easy steps you can take to get started and fulfill your proactive requirements under the law. We're going to be going over annual notice right now. You can add some of the key dates to your calendar as we go through this presentation. Have good lines of communication with your tenant wherever possible. We know sometimes that can be difficult, but the main point here is to just let your tenants know that you care about protecting their children. Let them know about the dangers of lead-based paint. Let them know that you think it's important to protect from lead-based paint. Let me go ahead and just realized I was hiding that slide there. So again, document some of the requirements, encourage tenants to let you know. Make sure you're using the required lease notice. Those are attached as handouts to this webinar, and they're also available on our website. Also, there's a link on our website to a course. It's a quick online course offered by the Federal Department of Housing and Urban Development called the Lead-Based Paint Visual Assessment Training Course. And you can use that course as an education in how to check for peeling paint hazards in your housing. We strongly recommend that you take that course. Then another tip is proactive maintenance. Repaint an apartment, take care of leaks immediately, repaint before paint starts peeling. All of those things will reduce the risk of lead-based paint hazards. Just a quick note that when we're talking about repainting, don't sand or scrape the paint. If you do that, then we're going to have a conversation about safe work practices. And last but not least, make sure your buildings are registered with HPD. Most of our audience here, you are probably already aware of this because we reach out to you using the registration emails. But one thing to keep in mind is that if there are staff changes in your management office, keep the registration unit updated. So a lot of times someone moves on from their job and then the office will forget to keep the registration updated. By registering, you will hear from us when you receive complaints. You will also get all of the updates to your email to lead-based paint rules so you can stay current with the requirements. All right, we covered the overall big picture of lead-based paint in New York City, and now we're going to dial in to two responsibilities, as I said earlier, the annual notice and investigation responsibilities in this section, and then in the next section, record keeping. So let's talk about annual notice and investigation. Annual notice is just one of owner's responsibilities, annual inquiry and notice. Even if it's not part of the annual inquiry, if a building owner learns about a leak or an HPD lead violation, a tenant complaint in an apartment with a child under 6, they need to follow up. And then there are additional responsibilities at apartment turnover. All of these trigger an owner's responsibility to do a visual inspection for peeling paint hazards in that apartment, identify any deteriorated paint, and in the case of turnover, a few other possible conditions, and then hire contractors to fix whatever issues are identified. The annual notice is just one of those responsibilities, the one that we're focusing on today. Now, the law is very specific and prescriptive in how this annual notice and inspection has to happen. So the inquiry has to go out between January 1st and 16th. This time period recently passed, so most of us New York City residents received this inquiry in our mail and we're familiar with it. The tenants have until February 15th, the day after Valentine's Day, to respond. And then once responses are received, the owner has an additional step of inquiry to take, which is the owner is required to visit units in person that did not respond in order to try and get an answer as to whether there's a child. Now, you're also free to call, email, or write the tenant. If you can get an answer that way, then you wouldn't have to visit in person. But if you can't get an answer, the building owner or super is going to have to follow up in person. So that's another part of the requirements. Then once there is a list of all apartments with a response, there's a requirement to notify the Department of Health of any units where the presence of a child could not be determined. The address for doing so is available on our website as well. And then with the list in hand of all units with children under 6, then the owner must check those units for peeling paint hazards, as well as building common areas. Now notice we keep mentioning visual inspection. So this is a visual inspection for paint that is peeling, flaking, chipping, damaged in some way, compromised in some way. You do not need to use an XRF machine, a paint chip test or anything of the nature. It's just going to be a visual inspection. Because remember, in a situation like this, if you are doing this process, it means that lead-based paint is presumed to exist in all of the units in your building. So we're assuming that there's lead, and then we're checking to make sure it's not peeling. Then the final step of this is to empower tenants by sharing the results of the inspection reports with them. And so that's the final part of the process. There's a expected form for the annual notice, a required form. These are available as handouts to this webinar as well, and they're available on our website. You notice HPD will update these every year, and there's an option for multiple dwellings and private dwellings. The difference is that window guards requirements are also triggered by the age of a child, but those requirements only apply in multiple dwellings. Again, that's buildings with 3 or more units. So you can have a version of the notice that asks both the lead question and the window guard question, or if you own a private dwelling and you don't need to ask the window guard question, you can go ahead and use the version of the notice that only asks the question about lead. Many building owners let us know that they like to hire an outside vendor to do this annual notice requirement. I know that the building that I reside in New York City does this, and that's completely fine. You're able to do that. Of course, we just encourage you to remember that ultimately you as the building owner or manager are responsible for complying with the law. So make sure that the vendor that you're hiring is responsible and reputable. And make sure that you're aware of any aspect of the responsibilities that the vendor is not taking care of. So presumably most of these vendors are not doing the follow-up in-person inspections, for instance. So if that's the case, make sure that you are ready to complete the other required steps once the vendor has done whatever you've contracted them to do. Okay, that's our overview of annual notice and investigation. When we do our record keeping demo in a little bit, we're going to just review all those requirements in even more detail. So this isn't the last that we'll discuss them, but now we're going to pivot and discuss a separate requirement under Local Law 1, the requirement to keep records of all lead-based paint activity, including but not limited to the annual notice and investigation. So the law requires building owners to keep records for at least 10 years related to all lead-based paint activity. Now, a small detail here is that the record-keeping requirement recently changed, as did several other requirements for private dwellings in February 11th, 2021. Private dwelling owners' responsibilities were expanded. So the turnover record-keeping requirements always did apply in private dwellings under New York City, the turnover activities record-keeping requirements. But the other record-keeping requirements only came into effect as of February 11th, 2021. So an owner of a private dwelling would not be expected to have records for the other requirements, for instance, annual notice and investigation, that go back further than February 11th, 2021. But again, for turnover records, the full 10 years of records would be expected. For keeping these records, details really matter, and we'll see this in the demo. So the law really prescribes a number of different steps that must be taken in order for you to show that you're complying with the law. You have to document compliance with each of those steps. And as you'll see in the sample forms, it's important to be very specific, to note when you did find hazards, to note when you didn't find hazards, to note when you did receive a response from a tenant, to note when you did not receive a response. So they have to be very detailed. Very important to keep in mind that these records must be designed to be shared. So it's required to save the 10 years of records. An HPD may audit or request these records. Some of the upcoming changes that we're going to see will involve additional records requests from HPD. So soon HPD is going to be requesting annual notice records when any violation is issued. So it's even more important now to keep these records available and organized. And if you are selling your building, you'll have to provide the records to the new owner. So what we recommend is to keep these records organized in one place for easy access. The analogy I like to think of is pocket change. It still has its value, but I can't really do much with it unless I have it all in one place. So for instance, just a thought, if your management office has a separate file folder for each apartment, for each unit in your building, where you keep all the records of repairs, for lead-based paint repairs, for anything that relates to lead-based paint, you may wish to keep an additional photocopy of those records in a separate lead-based paint folder. I'm not a building manager myself. I'm not sure how you organize your work. It's just an idea, an example of something you may wish to do. So that if you do receive that request from HPD for your lead records, that it will be as simple as going to the appropriate folder and just pulling the files instead of having to spend days combing through all of your old records going back 10 years and pulling and copying anything related to lead. And related to having these records easy to share, use notation on the records that anyone can understand. So be careful about abbreviations and things like that. And if you are keeping those records digitally, which is completely fine, try to format them in a way that they can easily be printed, that someone can read them. Okay. We provided the overview, the big picture of lead-based paint compliance for New York City. We talked about one example of owner's responsibilities, which is the annual notice and investigation process. Then we talked about record-keeping responsibilities. And now we're going to bring the previous two sections together, and we're going to use annual notice and investigation as an example of what it can look like to follow the law and keep good records of your lead-based paint activities. So we're going to use HPD's sample forms as a tool to help you document all of your required information. If you fill these forms out completely and thoroughly, you should be able to respond appropriately to an HPD audit. But again, I want to emphasize it is not required to use these forms. You're free to either use them or keep the same information in any other format that fulfills the requirements. Again, you can find these forms by visiting our website at www.nyc.gov/lead-based-paint. And we have also attached a PDF of all of the forms together to this webinar for those of you who are joining us live. Now, important to understand about using these forms is that they're a helpful tool, but in order for these forms to work, you still have to fully understand the requirements. So they aren't really like, say, a 1040 easy form, where if you just follow the instructions and fill out all the boxes where prompted, you can be sure that you've followed the law to the fullest. These forms are an aid, but you need to know what you are trying to document. You need to understand the requirements for yourself in order to use them, and you will have to adapt them as needed. In creating this demo, I identified some cases where I felt like I'd probably want to adapt the forms if I was a building owner. And so I included those there just as examples of how I might do this as a building owner, but you'll be able to use your own judgment. You're also going to want to be sure to attach all necessary info. So you're going to be attaching a lot of other documents to the forms. And again, you're just going to want to be extremely detailed. So you want to document following every single step that you take to keep your tenants safe from lead-based paint as required by law. And you'll see what that looks like in just a moment. That's the last few other notes before we get into our demo. I've added a lot of colors to this demo. That's for presentation purposes only. That is not required for you in keeping the forms. It's just going to help us keep track of when different steps are completed in this demo. And again, this will show you how you can use our sample forms as well as help us review the annual notice and investigation requirements. Now, we are only providing a demonstration for annual notice and investigation, but you can use the same principles to fill out other HPD sample forms, as well as keep your own records of requirements that HPD does not provide sample forms for. So in conducting our demonstration of annual notice and investigation for our imaginary building, we're going to be using 5 forms. The 2 forms on the left have to do with our annual inquiry. We've got a form that summarizes all of our efforts to inquire with tenants, and then a separate form where we make a note of anybody who did not respond when we inquired. And then the forms on the right will summarize our follow-up efforts to inspect apartments where we've learned that there's a child under 6. So we'll have a summary of all our inspection efforts. We'll have a report that we're going to fill out for each apartment that we inspected. And then we will have a form that we're going to use to indicate any apartment where we did not complete an inspection. So 5 different forms. We're going to start with our summary form. And here you can see a form that I've filled out with information for an imaginary building owner at an imaginary address. And for our demonstration, I have pre-populated this form with all of the information that I already know about my imaginary building. So I already know the apartment numbers. I already know that one of my apartments, 3B here, if you can read the writing, is exempt. I got an HPD exemption. And so for that apartment, I'm able to put a line through all of the other rows because I don't have to do the annual notice investigation for that apartment. Just another example, I happen to know in my imaginary building that one apartment is vacant. And so there's no checkbox or column to indicate a vacant apartment. And so I have to use my own judgment and just adapt the form to indicate that for this vacant apartment, I obviously do not have to do the annual notice and investigation because I know for a fact no one is living in that apartment. And instead, I'm actually thinking about the turnover requirements. Now, just another quick note about these forms. There's some additional helpful information at the top, including the deadline for the tenant to respond, which again is February 15th. A list of things that you have to attach to the form. And there is a signature field here. Wait to fill out the signature until the form is completely filled out. So don't sign it until it's done. So we've got our list of all the apartments in our imaginary building here. And we filled out any information we already know. Next, after we send out our annual inquiry, we can fill out another part of the form. And so that text is indicated here in blue. And in this imaginary example, we sent everything out on New Year's Day. And we're also indicating the method of delivery. So in this case, mail, but you can see email or hand delivery are also options, and who it's delivered by. So in this case, in my imaginary building, I had my super handle this process, but other folks, it's a little, will use third parties, a third party vendor, and that's completely okay too. I'm just going to indicate all of that information in my sample form. Now from here, we're going to give the tenants time to respond. And again, it indicates at the top of the form, the tenant has until February 15th. And now the green text that I've added indicates the tenant responses in my imaginary building. And you can see that some tenants did respond and some didn't. That's indicated here in this column. And then of those who did respond, some had a child under 6 in the apartment, spending 10 or more hours per week, and some didn't. Then you can see that I indicate how the tenants responded, and most of these tenants responded in writing. But let's pretend there's one tenant where they actually didn't respond to my mailing, but I bumped into them in the hallway and discussed the topic with them. And so for them, I indicated a verbal response, and they told me they had a child. So that's how I collected that information. You know, for all of these cases, I want to save the documentation I've received showing my efforts and showing what the tenants responded. If the tenant responded verbally, maybe I could write myself a memo or an email, make a copy of that and save that as well. So now we have a list of all apartments who responded to our inquiry, but we're not done because as I mentioned previously, owners have a responsibility to follow up where tenants didn't respond to the annual inquiry with additional efforts. So here I've highlighted all the apartments that didn't respond to my inquiry and I didn't get an answer one way or the other. So for them, I haven't been able to complete some of this form yet. And what I'm going to do is I'm going to add all of those apartments to our next form, the form summarizing apartments that did not respond. And again, the required steps here are very specific as elucidated in the law, as spelled out in the law. So this form and all the forms together are really going to help me show that I followed each exact step of how the law expects me to look for children under 6 in my buildings. So now in this new form, I've started by listing all of the apartments where I didn't get a response to my mailing. And my next question is going to be, well, maybe I still do happen to have information about a child. And if I do, then I can go ahead and indicate that a child exists in that apartment, even though I didn't get a response. If I know for sure there's a child in that unit, maybe the tenant moved in the previous month and, they told me there's a child living there for sure. In that case, I can go ahead and I don't have to follow up with a follow-up inspection. I can use my actual knowledge. And I would probably document how I know as an attachment to this no response form. But for most of the apartments that didn't respond, I don't know whether there's a child. I don't have specific information that there is one. So I'm going to have to follow up in my imaginary building. So I sent my super in my building out to do in-person follow-up inspections. You can see that my super is very responsible, and they went out on February 16th to each apartment. And for most of the apartments, they were able to access the apartment and confirm whether there's a child. But for one apartment, they didn't access the apartment on the 16th, and they have to now make additional visits to see whether there's a child in that apartment. So they went back February 24th and February 28th in order to identify whether there's a child. And in this case, they never got a response. Let's imagine in our example that the tenant finally answered the door and said, I'm not letting you in. I'm not going to tell you either way. Please don't come back. And so again, I would make a notation of that. If possible, ask the tenant to sign something, depending on if the tenant is willing to. It's not strictly required, but it might be helpful. And then for that one unit, I'm going to send notice to the Department of Mental Health the Department of Health and Mental Hygiene. Again, the address for sending that notice is listed on HPD's lead-based paint page of our website. And I'll just keep repeating it. It's www.nyc.gov/lead-based-paint. So you can find that address there for making that notification. And again, we see on this form that some other things that must be included are noted in the instructions, so very important to read those. So proof of mailing the request for access to the tenant, and a copy of the notice that you sent to the Department of Health and Mental Hygiene should be attached. All right. So now our inquiry process is completed. We're also going to quickly add that apartment where the tenant refused to respond to our list of all the units where we couldn't do an annual inspection, which is going to be a separate form that we'll come back to. And now we're ready to finally fully complete our annual inquiry form. And so the text indicated in gold here just fills out what we couldn't fill out before we did our follow-up inspections. Is there a child in the apartment? And then for these cases, we always indicate that our answer was based on the owner inspection. With those answers in hand, we can now make a list of every unit where we know there's a child under 6. And that's the same thing as making a list of any unit that we must inspect for peeling paint. And so now we're going to highlight all those units with children under 6. And we're going to use those units to get our annual inspection summary started. So now we're moving to our summary form for the annual inspection. We add every unit with an apartment that has a child, every unit with a child under 6. And we're going to document that we sent written notice to request an inspection. And in this case, we sent all of these notices on March 1st. Of course, for simplicity's sake, I'm having a lot of these events in my imaginary demo take place on the same day. And in real life, it won't always be that simple. You'll probably have a lot of different dates, depending upon when you're able to complete some of these tasks. And we're making a note here of the reason for our visual inspection for lead-based paint hazards, which is it's related to the annual notice. You'll notice this form also lets you include occupant complaint. You could potentially adapt it for other factors as well, because remember, you also have to do this visual inspection for deteriorated paint whenever you receive information that paint in a unit with a child under 6 could be compromised. So maybe you learn of a leak, maybe the tenant complains to you, maybe you receive an HPD violation, whatever the case may be, that also triggers this responsibility for an inspection for compromised paint. So we sent out our notice and we've indicated our reason. We've added, we've started filling this form out. And now in our imaginary example, we're going to pretend that we sent our super, Jane Doe, out to do all these visual inspections. And Jane Doe is a very hard worker, and she actually managed to complete all of the, attempt all of the inspections on March 5th of the year. So we can now indicate when the inspection was completed or when it wasn't, whether it was performed by the owner or agent or a third party, and the name of the person. So in this case, we have Jane Doe, and did they find lead-based paint hazards? Now, we have another step to take with this apartment where we couldn't get access, where Jane Doe couldn't get access. So for this apartment, we're not able to complete the rest of this form, but we're gonna add this apartment as well to our list of apartments where we couldn't do an inspection. So now we have 2 apartments on that list. One apartment that refused to cooperate with our initial inquiry, and one apartment where we got an answer to our initial inquiry, but then we couldn't gain access to actually check for peeling paint hazards. And now, let's take a look at our final form that we're going to want to examine, which is the apartment report form for every apartment that we could inspect. So let's look at it's apartment 3A in this example. This is just one apartment, but I'll need to create this form for every apartment that could be inspected. And that's this apartment report form. And this form allows whoever conducted the inspection to make detailed notes of what they found. Again, you'll need to adapt this form a little bit. It allows you to list the room that was inspected, as well as the surface. You're going to want to indicate the surface where the problem was found. And now notice all this language here in the middle of the form. This is sort of very technical, precise language asking about peeling paint, such as curling, cracking, scaling, flaking, blistering, chipping, chalking. And then it asks some questions about teeth marks, deteriorated subsurface, etc. And so sometimes people are wondering, why is the form structured this way? The answer is that these different columns list all of the specific things Local Law 1 expects you to check for. And so it just helps you really document step by step that you are following all of the concerns of Local Law 1 to a T. And so that's why you have all these different categories. And in some cases, you might say that the paint is peeling and the painted area shows impact damage. Both of those things might apply in a situation. You might have yes for both categories. And notice that the form asks us in filling out these forms to indicate when we did find a hazard and when we didn't. So for some rooms in this imaginary apartment, the kitchen and the bathroom, in my imaginary example, I didn't find any hazards, but I still list that room and write no in order to fully show that I inspected the entire apartment. And now in the living room, I found a lot of hazards. So in that case, I made multiple entries and then I specified what hazard. And again, I added the location and description in the notes. So whoever actually conducted the inspection has to fill this form out, and they should sign it once they're done. And then, as I mentioned a little bit earlier, part of the law requires us to empower tenants with knowledge by sharing the results of this report. And now we're going to go back to our summary form of our annual inspection efforts and show how we complied with that part of the law. So did we provide the written results? And in this case, the answer is always yes. And what date we provided those. And again, I may wish to attach additional records documenting the fact that I provided this report. All right, that was our demo. I know it's been a lot of information. I'm sure there's a lot of questions. Before we get to those, I'll just go ahead and provide some additional final notes and a few pieces of wrap-up information. There are some responsibilities that aren't actually mentioned in HPD sample forms at this time. The inquiry at lease up. So most of you are aware that there's a required lease notice where you're also asking about children under 6. Addressing whenever you learn a peeling paint in a unit with a child under 6, not just annually. And also the newer requirements to test all units and common areas in a building. We don't have sample forms for that responsibility yet. So you can use the principles and ideas that we have shared in this presentation and that you see in HPD sample forms in order to keep your own records for those other responsibilities. Generally, at this point in the presentation, we'll have some members of our audience who are telling us that they're only now realizing about a lot of these requirements. And so the question is, what to do next, what will happen next? So our advice is to compile any of the records you do have relating to lead-based paint, going back at least 10 years as required by law. Any repair records, invoices, emails, descriptions of work, any records of testing that may have been done in your building. Now, if you haven't been keeping the records, if HPD selects your building for an audit, this says you may receive a violation, but really you're going to receive a violation for that, and then you'll receive instructions from the lead-based paint unit on how to move forward with that violation, but it is something to be aware of and be ready for. Again, getting your records organized and improving your practices going forward is going to be the first step in dealing with that situation. And something to keep in mind when buying a building, ask for those required 10 years of records. If the owner doesn't have the records, you can contact our lead-based paint unit and they can provide guidance on filling out an affidavit, but hopefully you can just get those records when the building sale is completed. Now, I mentioned this a little earlier. We do want to highlight that there have been a lot of laws passed relating to lead-based paint with additional news and responsibilities. Coming soon, there's going to be an additional option for dismissing HPD record-keeping violations. Previously, an owner would have to provide 10 years of complete records in order to get the violation dismissed. But there's going to be an option to provide at least 3 years of records and then pay a fine for the 4th, 5th, 6th, 7th, 8th, 9th, and 10th years of required records. So that is something that hopefully will be helpful for owners, where if you've been having trouble, especially if your building has received an audit and you are working on getting into compliance, this gives you a 3-year period to work with where you may be able to get that violation dismissed. We always had a testing requirement for not always, but since recently there was a testing requirement for all apartments in the building, but that requirement will soon be expanded to common areas. Soon, HPD inspectors will also be issuing lead-based paint violations for common areas. And especially relevant for today's discussion, there are a number of changes coming where HPD is going to be requesting required records whenever a violation is issued. So taken together, the real takeaway for a lot of this news is that it will really benefit you as a building owner to get your record keeping in order. If you haven't already, just start keeping your records organized. And to arrange for the required testing, and wherever you can, watch our exemptions webinar and apply for exemptions for your units or for your building. All of these things are good proactive ways for you to keep your tenants safe while also being ready for some of these requirements that are going to come in. Additionally, in 2025, some requirements to abate door and window friction surfaces will be expanded. Previously, this type of work had only been required when an apartment is vacant during the turnover period, as we say. But soon that will be required for all units with children under 6. So this is a lot of news. This is just a preview. We are going to be releasing additional information on the details as it is finalized, but we do want to make all of you aware. You can also check our website, again, www.nyc.gov/lead-based-paint, and you can check owner bulletins for additional details on these requirements that as they have been released now. And there's plenty of more on our website. You can look up your building on our HPD Online database. You can get help with property registration and get lots and lots of details about specific maintenance requirements. And this is the lead-based paint page I keep mentioning. There are briefings and webinars where you're going to find a lot of the information I've referenced. If you would like to find our sample forms, that's going to be found under a record keeping tab that you can go find on our lead-based paint page. Now we're getting ready to open the floor to questions, but one other thing I want to point out is that when we answer questions, we won't be able to help you with your specific situation. So for anybody who'd like help with a specific situation, please go ahead and contact our lead-based paint unit, which you can do at 212-863-5501. And that's available, but I'll repeat it just so people have time to write it down if they need to. 212-863-5501. So for your specific situation, contact the lead-based paint unit. And as we've said, there are plenty of other webinars to come. There's plenty of places to get more information. And do take a moment to fill out the survey if you'd like. And in case anybody has been asking, by attending this webinar live, you will automatically receive a link to an email with a link to a recording of today's webinar within about a day after we concluded. And we'll also be posting this video to our website and our YouTube page. So you'll be able to find it there at the very latest by Monday, probably sooner than that. Okay, you've been waiting patiently for your questions, and we'll try to answer as many as we can. Just to let everybody know, we have over 300 people joining today, so we won't be able to answer all of your questions. But let's go ahead and get started. Chief Ayub, what questions are you seeing come in that you would like to answer?
Well, I haven't seen any questions coming in yet, so I highly encourage the audience to submit your questions, and we'll try our best to answer.
Okay, I am seeing some questions that came in. Chief, take a look at the questions panel one more time. I saw a question that came in from Lisa. And Chief, I'll throw this question to you. Lisa has shared the XRF testing report for individual apartments with the tenants, and she's asking, does she need to share the XRF report regarding the common area?
Only if the tenant requested, though.
Okay, great, thank you, Chief. So Lisa, in answer to your question, now this is in relation to XRF, the XRF testing requirement. So this is a separate question from the question of our annual notice and inspection. And remember, in those cases, the kind of inspection that's required is a visual inspection for peeling paint. Chief Ayub, I'm seeing a question from Deborah. Deborah is asking, what are our responsibility for shareholder apartments with owner/shareholder tenants? Can you talk us through those requirements?
Basically, for condo and co-op owner-occupied units, you're exempt from local law 1. Local law 1 only applies to you if you start to rent those units out. Once again, if you're the owner and you live in the unit or your family lives there, you don't have to comply with local law 1. However, from the first day you start renting a unit out, local law 1 will apply. That means you will have to give out annual notice and do the investigation as appropriate.
Okay, I saw another question that came in from Richard, asking again about the XRF requirement. Richard asked, if there are no children in the apartment, is it still necessary to complete the XRF testing? And Richard, the answer to that is yes. The XRF testing requirement applies to all units in the building, and as we said, will soon expand to common areas as well. Okay, Chief, I see another good question coming in. This question is from Corey. Does a commercial store on the ground floor, is that considered as a dwelling unit? Do they need to sign the form? Yes, go ahead.
No, Phil, unfortunately not. The law only applies to a residential unit. Any unit that's commercial is exempt. For example, in this case, the store.
Okay, and yet, Chief Ayub, that's even if it's an after-school center where there are children who spend more than 10 hours per week inside?
HPD does not inspect a commercial daycare facility. That will fall under Department of Health.
Okay, thank you, Chief. Of course, just we want to make sure that that is zoned and indicated for commercial use. You know, if a tenant is running something out of their apartment, then that's going to be a different situation where children would be said to reside in that particular unit. We've got a question from Chris. That's a common question we get that I'll answer. Chris says, I own and live in a 6-family brownstone. I see tenants every day and know there are no kids. Can I self-report or must I still send and file the paperwork? And Chris, I'll let Chief Ayub add any details that he likes, but the answer is you still have to follow all of these prescribed steps under the law. So even though you know that there are no kids, the law is very particular in how it expects owners to make these inquiries, and it doesn't leave a lot of wiggle room for your kinds of situations. Although, as we went through the demo, you probably noticed a few areas where your situation will streamline things a little bit, but yes, you still need to do the annual notice. You still need to follow all of those steps. Chief, I don't know if you noticed any questions or I can keep throwing them at you.
Keep throwing them, Phil. I'm having a little technical difficulties with the questions.
Okay, no problem. let's see. We had a question, so this is really around the XRF testing requirement, which we didn't focus on today, but it's a great question. The question was how do I get certified lead inspectors in New York City, and how much does it cost to take and get certified? Oh, actually, I think I misunderstood this question. So in terms of if anyone is interested in becoming a lead inspector, there are various vendors. We can't recommend one, but there are different vendors within New York City that offer lead inspector training. Now, for building owners looking for a certified lead inspector, we'd advise you to visit the EPA website. They will have a list of certified lead inspectors. Now, we're receiving some requests for the PowerPoint, to share the PowerPoint. Unfortunately, we aren't sharing the PowerPoint presentation at this time, but again, you will have access to recording of this presentation. So you will have that as a resource, but we are not sharing the PowerPoint at this time, for those of you who are asking about that. We got a question from Thomas, who asked, when is the deadline to perform the visual inspection after the owner finds out a child under the age of 6 lives in the unit? Chief Ayub, is there a deadline in the law for that particular step?
It does not state when, but it has to be done before the calendar year is out.
Okay. Yeah, great question, Thomas. Thank you for that. Let me see
Also
here.
have a question here, Phil. It's from Jane. She wants to know, for the annual notice, do they send that to HPD? And the answer is no. Those annual notice record you keep to yourself, and we will request it if we ever need it via written notice to you.
Okay, good question. Chief Ayub, we're getting a lot of questions about the testing requirement. One question is, if the super has a lead inspector license and has their own lead inspector business, can a building super complete that inspection? Or does it have to be an independent inspector?
According to the law, Phil, there might be some technicality there whereby it might be a conflict of interest if that person's also doing lead abatement or lead remediation work in the building.
Okay, so it sounds like for a really it sounds like it would be worth calling the lead unit with that question, because there may be some specific details depending on the super's other activities. Is that about right?
Correct, Phil.
Okay, thanks for that question from Rodman. Let's see. There was a question about exemption from Guadalupe. Guadalupe asked, after August 2025, let's say we get an exemption. So does that mean after that we don't have to file an exemption every year? And if I understand your question correctly, Guadalupe, that's correct. So our exemption process, it's a one-time application. And after that, the exemption will remain in force. Unless, of course, for some reason we find lead-based paint in a unit that otherwise had seemed to be exempt, that could cause the exemption to be revoked. And there are some details with previous exemptions because the threshold for what constitutes lead-based paint was recently made stricter in New York City. And so we have a process for those exemptions become revoked that were based on testing at the previous limit. If you have questions about that, take a look at our exemption webinar.
And I highly recommend the audience to apply for an exemption from HPD. It's free, it's no cost associated with it.
Yeah, it will save you a lot of time and effort in the long run. We can also share that HPD is currently working on an online portal that should be making the exemption process easier. We'll share more details about that once it's live and ready to go, but we want to make the exemption process easier for you. And we are looking at other ways to make the best use possible of those exemption records and potentially streamline our inspections to include those exemption records where relevant. So we very much want to make exemption a quick and easy process as much as possible for you. And so stay tuned for that news. And in the meantime, take a look at our exemption webinar and go ahead and apply if you are able to. Let's see.
There's another question here, Phil, if I read it correctly. Do we need to hire a certified lead inspector every year? And the answer is no. Under local law 31 testing, you only have to test the unit once. So you do not have to hire someone to come every year to do your testing.
Yeah, that's a great question. And this is where learning these requirements takes a little bit of time because there are a lot of different requirements, right? So the XRF testing requirement is a one-time requirement. That's the requirement that you get XRF attesting for every unit in your building and common areas. And what that requirement does is it should create a complete record of where any lead exists in your building. And once that record exists, it should be good unless the threshold were to change again under the law. So that testing requirement is a one-time thing. Now, our annual notice and inspection requirement is different. In that case, we're checking for children under 6, and then we're checking for peeling paint in apartments with children under 6. So there's no need for a license for that inspection. As we said, you can visit our website and find the HUD visual assessment training, and that will just give you some guidance on how to do that inspection for peeling paint hazards. But there's no XRF machine or anything tested required for that kind of inspection. So there are a few different kinds of lead inspection and testing that are required in different circumstances under the law. We have a question from Cleveland Place Corporation asking, when will the 10-year record keeping requirement begin? So that requirement has existed since local law 1 was passed in 2004. So that requirement is currently in effect going back to, it's 2024 right now, so back to 2014. Everybody should have, in order to be in full compliance with the law, should have those lead-based paint records going back that far. There was a question about fines and pricing. We won't get into that right now, but should you receive a record-keeping violation, there will be more information for you there. Okay. Any other questions that you see, Chief?
There's one question here, Phil. Someone tested building and it's positive for lead, and they want to know if they have to take the lead out and rip every single component out. That's a great question. According to local law 1, and based on the information we provided earlier, if the paint is intact, there's no hazard present. So you could do monitoring, make sure the paint is intact throughout the year and do nothing. Or if you choose to, you may abate or remediate the paint.
So there are a few, and our exemption webinar provides more detail on this. There are, in treating lead-based paint issues, some different options. There are options to do work that completely removes lead-based paint. There are other kinds of work that will only stabilize and provide a temporary solution. And those options will require certain ongoing monitoring, but those can also be an option. Do keep in mind as well, as we mentioned at the beginning of the presentation, that it's not a violation simply to have lead-based paint in a building. The real focus is on hazards. So once you, when you do have lead-based paint, there are some different options if you'd like to address it, but most of the law is going to focus on hazards, which are going to be peeling paint, damaged paint, and in certain specific situations, paint on door and window friction surfaces that rub against each other on doors and windows. Chief, I see a great question that came in from Larissa. Could you provide some clarity on what is considered knowledge of lead-based paint that would make a post-1960 building regulated. So just to remind everybody, we mentioned at the beginning of the presentation that buildings built between 1960 and 1978 may still be subject to local law 1 requirements if there's actual knowledge of lead-based paint in that building. Chief, any insight you can provide there?
That's a great question, Phil. There's three ways of knowing if lead exists in your building. One is if you actually test the unit, or the tenant tests their unit and inform you there's lead there. The other is if the Department of Health issue a quota. I mean, they went there and they found lead, or HPD issue a 617 or 624 violation. So those are the three actual way you could find out if there's ever lead in your building.
Okay, and Chief, I see a few questions are coming in about testing in the common areas, and people are asking exactly what must be tested in the common areas. Someone's asking stairwells, risers, handrails, treads, floors. So
Every single paint component need to be tested.
Okay, great, thank you, Chief.
I have another great question that came in here. Phyllis asks about the XRF settings. What should the setting be? So for local 31 testing or any testing going forward, you need to get an XRF machine that's calibrated at 0.5 and has a PCS. Very important, it has to have a PCS from HUD with an action level of 0.5. So if someone have an XRF at 1.0, that's not going to work. So do your due diligence, do your research, and make sure your PCS that's being used has a PCS approved for a 0.5 action level.
Let's see, I think we have time for a few more questions. We're approaching 12:30, so we'll stop around then. I saw a good question from Kevin. It's really worth emphasizing. Kevin is asking if there's a unit that got tested and the lead was present and got remedied, do the annual notice inspection requirements still apply? And Kevin, the answer is yes, until you apply for and receive an HPD exemption. So the work that you've done to address those hazards can help you, but in order to get the benefit, you're going to want to take a look at our exemptions webinar and apply. And in addition, even once someone has an exemption, there's a distinction between a lead-free exemption, where monitoring requirements are basically go away. There are certain kinds of work that can address a lead paint condition, such as encapsulation or enclosure, where some monitoring will still be required, even if the annual notice and inspection are no longer required. Chief, I'll turn it over to you for one more question, and we do apologize. We have so many people here that we're not going to be able to answer all of your questions. But yeah, Chief, one more.
Go ahead, Phil. Present the question.
Okay. Let's see. So let's see here. Well, we have one question from Najema asking, do we have to do XRF testing and report for building laundry rooms where kids often are with their parents? So the answer there is that the requirement will soon be come into effect that you have to do the testing for all common areas. So the requirement really says all common areas, whether or not children spend time there. So certainly a laundry room would count.
Well, according to the definition of common area, right, is the path used routinely by the tenant to go from and leave their apartment. So in this case, a laundromat will not be considered a common area for exemption.
Okay, my apologies. So that's why we have the chief here, who is the foremost expert. So you will not have to do the XRF testing in the building laundry room. Thank you for clarifying, Chief. Okay. Thanks again to everybody who joined. There are some people asking about the cost and cost of hiring inspectors and if we can recommend vendors. Unfortunately, we can't. So you'll have to do your own research on that. And again, we will refer you at least to the EPA website where you can confirm that the vendor has the proper license. And with that, we're going to wrap things up. I want to take a moment to thank everybody for spending time with us here, learning how to comply with the law and keep your tenants safe. It was a pleasure speaking to everybody today and answering your excellent questions. And Chief, any final thoughts for the group before we log off?
No, it was a pleasure being here today, and we see a lot of questions. For the folks who we were not able to answer your question, please give us a call at 212-863-5501, and we'll be happy to assist you.
Okay, have a wonderful day, everybody. Thanks, and we'll see you at the next webinar. Take care.